Well, this is a real pleasure to have an opportunity to comment at this conference, and especially on Bill's really wonderful paper, which I thought was really a delight to read and is really going to be a major, major contribution to early constitutional history. So this idea that Governor Morris effectively wrote the Constitution or was the person who on the Committee of Style was basically the one-man wrecking crew is something we've long known and people have long talked about. But amazingly, I think the first remarkable thing about this paper is that it's the first of its kind. Nobody to this point has offered a systematic study of what went into the Committee of Style and what came out. So that is the first way in which it is remarkable. And I think the second way in which it's remarkable is I think it's quite persuasive on a lot of fronts. Three in particular. I think Bill shows very well that Morris was in many ways a dishonest scrivener, that he did in fact take what went into the Committee of Style and try to backtrack a bit on things he had lost on the convention floor, or things he thought needed to go in a different direction, and used his talent with language to try to change that. I think Bill also does a wonderful job of showing how this dovetails with Morris's constitutional vision. I think he really effectively links all of these textual changes to things that Morris had long cared about in deep and systematic ways. I think the Contract Clause, the Supremacy Clause, and the Fugitive Slave Clause in particular, I thought the analysis there was really striking. And I think perhaps most importantly, you do a really good job of showing how all of this really matters in the 1790s, that it has a real impact on the constitutional debates that follow ratification, that a lot of the things that Morris puts in the Committee of Style are leveraged in very important ways. So I could spend most of this comment detailing all the things that I found persuasive about this wonderful piece and all the ways in which I thought it was great, but I'll instead try to offer some areas where I was either left a little confused or I really wanted Bill to push a bit deeper with the analysis. So I think the first one is, what do we really mean by the Federalist Constitution and this claim that Morris created it, right there in the title, the creation of the Federalist Constitution. Often the claim in the paper comes in very strong form. Morris created the Federalist Constitutional Playbook. In just a couple of days, I think you say on one page, Morris created the Federalist Constitution. One way to read these claims is, but for Morris's last-minute additions, there would not have been a Federalist Constitution. I don't necessarily think that Bill is trying to give us that strong version. It's a question of emphasis. How much did Morris give us the Federalist Constitution? But then that begs exactly that question. How much? And here I thought the paper was notably silent on all of the other things that had happened to that point in the convention that arguably contributed potentially to a much greater degree to ensuring that there would be a Federalist Constitution. So beyond the fact that the Virginia Plan sets the agenda and its basic framework more or less makes it through, national delegates are able to get in the taxing power, they're able to get in the necessary and proper clause, which is dramatically enhanced thanks to James Wilson on the Committee of Detail. They're able to get remarkable restrictions on state power, particularly to interfere with debts. They're able to vest vast prerogative powers in the new president. They're able, through Article 7, to get ratification directly by the people, and so on. So what is the bigger claim here in terms of relative contribution? How much of the Federalist Constitution is in fact owed to what Morris was able to get on through the Committee of Style? And another way of asking this question is, how many of the crucial post-1788 developments in which leading nationalists, Hamilton, Washington, Jay, others, shaped the new nation, how many of these were really owed to things that Governor Morris did? So incorporating the law of nations, using the law of nations to prosecute American citizens without a federal statute backing it up, solidifying the treaty power, dramatically expanding the financial system, all of these things we think of as part and parcel with the Federalist Constitution. To what extent is Governor Morris essential to how we ought to understand those things? It seems to me if one wanted to be skeptical, you could argue that many of those things would have happened regardless of what Governor Morris did on the Committee of Style. I don't personally think that. I think Bill does a good job of showing it otherwise, but I wanted a broader sense of context of sort of the high Federalist Constitution and exactly the ways in which Morris is in fact shaping it and giving it a more robust set of meanings. Related to this first point, I would also encourage Bill to not just lump all of the Federalists and the Nationalists together. Throughout the paper, Morris, Wilson, and Hamilton are trotted out as this sort of interchangeable troika, I think. And I actually think we can learn a lot more if we don't just look at the ways in which they agreed, but actually the ways in which they were subtly diverging from one another. And here I think Hamilton is really the critical figure. He's presented throughout the paper, and I think justifiably so for many reasons, as Morris's staunch ally. They agree on pretty much everything. They're working together, trying to get a lot of the same things. They're really partners in crime. But I think if we focus on some of the contingent choices that Hamilton makes in the 1790s, there are certain ways in which he undermines Gouverneur Morris's work as much as he reinforces it. I think we see this in the vesting clauses in the Pacificus Helvidius debate that you spoke to. Certainly, Gouverneur Morris was obsessed with expanding the powers of the presidency. But the choice that Hamilton makes, not just to draw attention to the vesting clause of Article 2, but to so systematically in such detailed fashion make the argument about how it is different than the Article 1 vesting clause, which carries with it the implication that national legislative power is in some unique sense constrained, I think very much cuts against what Gouverneur Morris was himself trying to do. I think Morris, we can see from his statements that he cared even more than he cared about the powers of the presidency. He cared about this legal category of the nation and the government of the United States that would represent that nation. This had profound meaning for him, like it did for Wilson, like it did for Jay, and I don't think he was trying to undermine that, undermine legislative authority vis-a-vis executive authority in the ways that Hamilton arguably did. I think we can also see this in the preamble. I think this captures their divergence well. As I think Bill shows well, Morris constructed the preamble with an interest in offering an implied grant of federal power. But it's really, really striking that Hamilton utterly ignores the preamble in the bank debate. Bill mentions this in the paper, but I think he kind of glides by this too quickly. I'm increasingly convinced, having spent more time than is normal or rational looking at the bank debate, just how distinct and exceptional Hamilton's opinion is compared to the floor arguments that are made by the bank defenders. If you look at what Fisher Ames, John Lawrence, Elias Boudinot, John Vining, Elbridge Gerry are arguing, they're usually making very different arguments than the ones that Alexander Hamilton puts in his opinion, and especially by making use of the preamble. The preamble is front and center in so many of their arguments. So I think it's really striking that Hamilton ignores it. And if you put together these two things, drawing so much attention to what Article 1's vesting clause says and ignoring the preamble in the way that he did, we're finding ways in which Alexander Hamilton isn't just reinforcing what Gouverneur Morris is doing, but in critical ways is undermining it. So if nothing else, what I'm trying to draw attention to is I think we can learn a lot more about Gouverneur Morris's Constitution, exactly the consequences that it carried with it, if we actually try to understand the differences between the Federalists, rather than just treating them as a monolithic block. I think seeing the gradations of high federalism and figuring out why some persist in the 19th century while others disappear tells us a lot about the extent to which Morris was or was not successful. Also, I think we need to figure out what I find to be a real mystery in an area that Bill otherwise covers so well, which is this crucial addition that Gouverneur Morris makes through the admission of new states provision. It's clearly an obsession of his. I think Bill shows this very well. He was against the admission of new states. He makes it very clear that he's concerned about demographic changes to the West, leading to a new kind of breakdown of political power that will overwhelm the much more enlightened, much more educated Eastern Atlantic states. And he makes a lot of changes, as Bill shows, that are expressly dedicated toward this end. He adds the territorial clause on August 30th. On August 29th, he removes the language that states have to be admitted on equal footing, and I think Bill shows all of this very well. But something Bill doesn't talk about, which I find utterly mystifying, given that Gouverneur Morris cared more about keeping new states out of the Union than anybody else. He cared more about keeping slave states out of the Union than anyone else, is he makes this remarkable change on August 29th that I can't even begin to make sense of, in which he reduces the threshold for how states need to enter the Union from a 2/3 congressional vote to a bare majority. He changes the whole language of the provision and gets rid of the 2/3 requirement. The Articles of Confederation had required 9 of 13 to add new states. Canada can get in automatically on its own if it wants to for geopolitical reasons, but 9 of 13, the Committee of Detail, Article 17, 2/3 vote required. Governor Morris, it says with Luther Martin in Madison's notes, that they changed this together, proposed it together, changes it from 2/3 to a simple majority vote. And you can argue that nothing was more consequential in the admission of new states clause than the fact that it was reduced to a majority vote. You can argue that nothing that Morris subtly changed in the Constitution ended up mattering more for subsequent constitutional history. Just think of the history of antebellum America. It's one long sectional struggle over adding new states that propels the nation toward civil war. We're but a week removed from the 200th anniversary of James Tallmadge introducing his fateful amendment into the bill in the House of Representatives to add Missouri as a new state, in which he tried to prohibit slavery in the region, which precipitated the Missouri crisis. As great a compromiser as Henry Clay was, as good as he was at negotiating, there was no chance, there was nothing available to the 16th Congress that could have met a 2/3 approval requirement. It barely passed by a bare majority, the Missouri Compromise. The same thing of the Compromise of 1850. 4 of the 6 provisions barely passed the House and Senate by bare majority votes. The Kansas and Nebraska Act, a 113-100 vote. So we're left with this strange paradox that the guy who wanted to keep Western states out and wanted to keep slave states out ended up making this change that made it very easy to add new states and made it very easy ultimately to add slave states, allowed the Missouri Compromise to take the form it did. And I think this is an important puzzle because this change is really entwined with a lot of the things Governor Morris is otherwise doing. And I would encourage Bill to try to make sense of it for me because I really can't make sense of it at all. And I will just close then with a word on Bill's reflections on what Governor Morris's Constitution means for originalism, because here I thought the paper retreated a bit from what could have been a more robust set of conclusions. The final word, as I take it, seems to be that all Morris could really add, and all he did add, was a healthy dose of ambiguity. So all he could really do was lay the groundwork for certain Federalist readings, but he couldn't really eliminate Republican ones. But were Morris's additions really all that much more ambiguous than what they replaced, or than other parts of the Constitution that he did not touch? Federalists and Republicans, of course, bitterly divided over all those other parts of the Constitution throughout the 1790s. And I assume they would have divided over many of the clauses that Morris touched, even if he hadn't touched them. So I think there's more to be said here. I think perhaps what Bill is showing us is not so much inherent ambiguity, but a topic that is near and dear to my heart, the ways in which the 1790s played a significant role in normalizing certain kinds of constitutional readings. Perhaps part of the reason we don't read the preamble as a grant of power is not because it's written in a particularly ambiguous way, but just because the Federalists failed as a political and ideological matter to entrench that reading as a normal component of constitutional discourse. And if we emphasize it in this sense, I think we get a different story than just being in the so-called construction zone, because I think the construction zone is understood as ambiguous meanings that are consciously given concrete definition. But that different way of understanding the 1790s and what comes or doesn't come of Governor Morris's textual additions would be how ambiguity is read out of certain kinds of clauses. That successfully entrenching certain constitutional readings means that generations thereafter no longer see that ambiguity. They are just normalized to the fact that this is the way to read it. So I'll end then where I began by saying I think this is a remarkable, a really wonderful paper. It's going to be a major contribution to early American constitutional history, and I merely raise these points because I'm eager to see it elevated to the highest form it might be.
Thank you.
Okay, Bill, you have a few minutes if you'd like to respond.
Yeah, first of all, Jonathan, thanks very much for those very thoughtful comments. You give me a lot to think through. And I also just want to say, I was a graduate student at Harvard when Jonathan's father was on the faculty, which is why I refer to him consistently by his father's name. So apologies for that, William. Just to go through, so what is Morris doing? There is a text, there's text that is Federalist text before the Committee of Style. In large part, Wilson is responsible for that. So, the way in which, I think of the Committee of Detail, and this is something Mikhail and I have really, this is one of the themes of the course that we teach on constitutional history. Wilson and the Committee of Detail creates a lot of Federalist text as well. What Morris is really doing here is, I think with remarkable anticipation, he's thinking about what the big issues are, and he's creating text that builds on what's already there, that the Federalists can then rely on in the 1790s. And it's very striking to me. If you think about what are the big constitutional debates, the Bank of the United States, judicial review, the Contracts Clause, the assumption of state debts. In each case, he creates language that the Federalists then rely on. There was other language that they could have drawn on, but, again and again, they go to language that he inserts at the last minute. I think in terms of, and I think it's a good point to think about kind of the split between Wilson, Hamilton, and Morris. Again, one of the things that I've been struck by is, I think, for example, Pacificus, the textual arguments that Hamilton makes are so subtle. And the herein granted, argument in particular, that seems to me that they're likely kind of working together and thinking through, what arguments could be for a broad executive. I don't think Hamilton in the Pacificus debates is arguing for a limited legislative power, but so he doesn't make that argument. I think one of the things that I have to, think through is on the Bank of the U.S. debate, he doesn't rely on the preamble, whereas the Federalists in Congress do. And, what his kind of strategic thinking is, that's really a question for me. And Hamilton does not rely on the preamble at any point that I'm aware of, in a way that, for example, Fisher Ames, who's very close to Morris, does rely on the preamble. The new states, I have to think, I don't have an explanation for why he shifts at the end. I think that's just that's something I have to work through. Whether he doesn't think it's going to make a difference and he wants to kind of build bonds with the Southerners, but I don't have a good answer to that. And the other question that I just don't know the answer to is why when Kentucky and Tennessee are up for inclusion in the Union, nobody argues that this is unconstitutional. That's something that I really struggle with. But again, I think that overall, I think of Hamilton and Morris as very much in alignment. With the preamble being the one thing in which there's a difference between them. And then just two closing points. One thing that a number of you have kind of said to me that in the next draft I'll be more careful on is, I talk about how originalists today kind of embrace a Jeffersonian vision, which I think that's overstated. What I would say is kind of the dominant originalist view is to embrace the Hamiltonian view on, for example, what we think of as Hamiltonian, I would think of as Morris's view on executive powers, but more of a Jeffersonian view on national powers. Again, the Contracts Clause, that's, one of the things that I think originalists have done is, they challenged what the classic reading of the Contracts Clause was that the original understanding was that it didn't apply to public contracts, right? And to say, no, in fact, read the text. Public is not in, private is not in the clause. And that's one of Morris's substitutions. So when King proposes the Contracts Clause, he says, let's take the Northwest Ordinance. The Northwest Ordinance says that you can't interfere with private contracts. And then Morris takes out the word private, and then Hamilton, in an opinion on what becomes the land issue in Fletcher versus Peck in 1796, says, it's all public contract, covers public contracts as well. So, so I think in terms of, one of the things that, for modern jurisprudence that I think is profoundly interesting is Morris doesn't align with kind of either wing of the court consistently. He's very pro-executive, but he's very pro-national, to the extent that that's kind of, the core split. And then I think, the other question, when you think from an originalist perspective is the 1790s is a great run for the Federalists, and then it's over. So they, all of the things, all of these things, the foundations of judicial review, actually that endures, but, the strong executive, the strong national government, the Bank of the United States, the Sedition Act, the lower federal courts, the Federalists run the table in the 1790s, and then they're gone. Right, so So I think that's kind of one of the larger jurisprudential questions. How do you understand text when there are two rival texts, two readings of the text? One is dominant in the 1790s, but then loses out. And so so for example, you always look on the preamble. You look at Justice Story says the preamble is just hortatory, right? That's not the way they see it in the 1790s, but quickly. The Federalists lose. And then the final point is, and the Federalists, they're not, in most of these arguments, they're not relying just on Morris's text, like in the Bank of the United States, but, it's a critical part of what they rely on. So, again, how do you interpret text when there are I would say, and again, I'm pushing back on this part of your criticism, there are multiple readings of the text, and this is not, for some of the text, this is not the only Federalist reading.